very good day again from the Permanent Bureau of the HCCH. My name is Gérardine Escolar, Deputy Secretary General. Thank you for joining me today at the last session of the inaugural HCCH CODIFI conference, the conference addressing private international law issues in commercial, digital, and financial law. In closing the HCCH CODIFI conference today, I thought I would give you a peek into the participation, representation, and statistics before going into a brief overview of the various threads of conversations and insights from our expert speakers this week. The HCCH CODIFI conference brought together 93 speakers from every continent in the world except for Antarctica. The gender representation of speakers was close to parity, with 48% identifying as female and 52% identifying as male. Just shy of 700 people registered to join us throughout the week. In terms of participants, taking into account the approximate 10% of participants whose locations could not be fixed, perhaps in a nod to the digital economy, live participants throughout the week saw representations from all major regions of the world. 30% joined us from Europe, with another 30% from Asia and the Pacific. Nearly a quarter of participants joined us from the Americas, and we also had representation from the Near Middle East and from Africa. The week-long online program had a total broadcast time of more than 32 hours of content. The CODIFI conference was built around 6 tracks. 3 focused on existing HCCH instruments: the 1985 Trusts Convention, the 2006 Securities Convention, and the principles on the choice of law in international commercial contracts. The other 3 tracks focused on the private international law issues surrounding the growing digital economy. Frameworks in the new decentralized economy that is based on technologies such as distributed ledger technology, or DLT. Relationships as DLT and other technologies such as automated contracting and algorithmic law are applied as building blocks for governance of enterprises, transactions, financial services, dispute resolution, operations management, and sustainable development. And innovations in the financial technology or fintech industry, including digital commerce. Allow me to give you a brief overview of the input and insights that experts have shared with us throughout CODIFI Week. Turning first to the Trusts track, speakers addressed the history and challenges of the HCCH Trust Convention from both the practitioners' and academics' perspectives. One expert affirmed that the HCCH Trust Convention remains relevant, especially for jurisdictions that do not have a framework for the institution of trusts. However, certain technical questions were raised about the current text of the convention, with some speakers wondering if work should be carried out in order to provide more guidance on their interpretation. For example, one expert asked whether Article 7 of the Trust Convention should be used to identify a law under which the trust is valid, noting that while scholarship suggests this is so, such an approach does not appear to align with jurisprudence in some courts. Experts also identified some barriers to the ratification of the Trusts Convention, focusing specifically on the interaction between the Convention and domestic taxation regulations. Among the various topics and issues that the experts this week touched upon as possible future work opportunities are: first, a potential review of the Trusts Convention to provide further understanding of what trusts are, taking into account recent case law, which may differ somewhat from the traditional approach that trusts involve having legal title in the hands of the trustee and equitable ownership in the trust of the hands of the beneficiaries. Second, possibly adding a list of fiduciary duties that a trustee must be held to, upon which they stand to be sued for in event of the breach of trust. Third, the consideration of a new regulatory framework that addresses practical implementation issues, including rules applicable to a trusts register. Fourth, possibly clarifying or providing guidance in the interpretation of the text of the Trusts Convention, for example, the term equitable ownership, in order to overcome any misunderstandings of trusts that may exist. Fifth, consider the working with the wave of civil law trust initiatives that have emerged recently in jurisdictions such as China, Hungary, Israel, Japan, Korea, Switzerland, and in various parts of Latin America. These jurisdictions have developed institutions analogous to trusts in the years following the conclusion of the Trust Convention. An engagement would support a wider understanding of trusts and institutions analogous to trusts. The second track of the CODIFI conference focused on the HCCH Securities Convention. In this track, speakers discussed the benefits of the convention for financial institutions, namely the legal certainty it provides, for example, in the case of bankruptcy or insolvency of a counterparty, and the practical implications in terms of applicable law to securities and perfection of transactions. Speakers also noted jurisdictions signatory to the convention that had applied its conventions and provisions domestically, noting that the convention is internationally recognized, simple, easy to follow, apolitical, and provides certainty. One expert noted that the solutions foreseen in the Securities Convention of using the place of relevant intermediary approach or prima factor would not prejudice the substantive position of creditors and other third parties. To the contrary, it allows to provide certainty and protect parties vis-à-vis the collateral taker. Some experts felt that the rule of negotiable instruments had been left out of major law reforms. There is a need for an overhaul in conflict of laws rules applicable to negotiable instruments. However, other experts noted the importance of revising current positions instead of revising the convention itself, preferring to focus on how actual market practice may be conciliated with the Securities Convention so as to avoid loopholes. An expert also noted that the party autonomy principle should be applied to negotiable instruments, as this principle facilitates certainty, predictability, and liberal autonomy. Experts agreed that, with development of DLT, blockchain, and tokenization, the Securities Convention may be up for a review in order to update the scope and topics of the convention to deal with these changes. Revisiting the Securities Convention in light of DLT would be important, according to one expert, because a lot of money could be saved for a lot of people if trading, clearing, settlement, and the holding of securities such as shares and bonds are organized in a different way. An expert also suggested expanding the Securities Convention to include intermediary holdings in relation to crypto assets. Another expert noted the review work of the Securities Convention will have to take into account the fact that the original peer-to-peer approach of Bitcoin and other cryptocurrencies is disappearing. Now, the third track of the CODIFI conference dealt with the principles on the choice of law in international commercial contracts. Speakers noted that the principles have been an inspiration for the creation of domestic choice of law legislation, for example, in Japan. One expert noted that the principles on choice of law assist the application of the United Nations Convention on Contracts for the International Sale of Goods, or UNCISG, by reinforcing and expanding the application of party autonomy, especially in developing countries, and by encouraging the recognition by national, private, international law legislation of the choice of non-state law as applicable law. This expert also discussed how the principles may contribute to developing the interpretation and application of the CISG. For instance, where the commentary to the principles discusses scenarios relating to the battle of the forms under the CISG. Several experts also recommended expanding the principles on choice of law to add principles to govern contracts in the absence of an express choice of law by the parties. Areas of future work that some experts suggested in relation to the HCCH principles on choice of law include: first, determining the scope of party autonomy, particularly with relation to non-contractual issues. Second, the law applicable to electronic consumer contracts. Third, novel types of contracts and transactions, such as cross-border transfers of data, which remain largely subject to different national laws. Fourth, the application of the principles to smart contracts that are created exclusively online, and in particular, their application to crypto activities and intermediaries in the crypto space. Fifth, studying whether the concept of internationality in Article 1, Paragraph 2 is relevant and can be adapted for the digital economy and for blockchain transactions. Sixth, studying whether the applicability and effectiveness of Article 3 for e-commerce actually would work. And seven, studying whether the Article 1 presumption of legality should be reconsidered in light of the potential risks of exploitation in digital commerce. Now, the other three tracks of the CODIFI conference focused on the digital economy. Over the last week, experts joining us on these three tracks suggested various private international law issues that may benefit from potential future work. These include a deeper analysis of possible connecting factors and the characterization of digital assets. These may enhance the legal understanding of digital and blockchain assets as they evolve. Potential future work on smart and automated contracts, the recognition and enforcement of transactions and decisions involving digital assets and the enforcement of, for example, court-ordered provisional measures was also suggested. Experts also touched upon specific applications, topics, and sectors in the digital economy that they suggested may benefit from future work in relation to private international law issues. One expert suggested that there is a need for future projects facilitating the recognition of decisions rendered involving blockchain systems, possibly in concert with the UN Commission on International Trade Law, UNCITRAL. In relation to central bank digital currencies, or CBDCs, another expert noted that private international law rules will need to balance between flexibility and predictability and should be forward-looking, with work started on it now, rather than waiting until CBDCs have been put into practice. Private international law matters that arise in CBDCs, according to this expert, include jurisdiction in relation to intermediaries, recognition and enforcement of judgments in CBDC systems, interoperability with existing financial systems, whether to treat account-based CBDCs and token-based CBDCs as tangibles or intangibles, and private international law considerations relating to data flow and regulation. In relation to developments in the use of metaverses, one expert noted that the off-chain enforcement raises important private international law questions, including the question of where recognition and enforcement proceedings of a transaction carried out in the metaverse should be initiated. This expert thought that guidelines and rules that allow for some cross-border certainty and harmonization between states would be helpful. Still considering the issues that arise in the use of metaverses, another expert noted that determining the applicable law is increasingly important and perhaps should be regulated by an international treaty. Potential issues in this regard concern due process, incapacity, or the award being contrary to public policy. This expert noted that the creation of specific solutions relating to jurisdiction, applicable law, and enforcement of metaverse-related disputes need to be based on the specific contours of the metaverse, which is a decentralized, dematerialized virtual world in which anonymous avatars are transacting. According to this expert, the use of a metaverse to carry out a transaction is enough to make the transaction international, making each transaction subject to the relevant conflict of laws applicable. Another expert addressed the question of global value and supply chains. This expert noted the importance of work in relation to the choice of forum or court, since absent a valid choice of court clause, traditional factors like place of business, place of habitual residence require parties to be identified, which may not be necessarily possible. The expert also suggested a rethink of the impact of private international law implications of transforming documents into data may be necessary, since the reconfiguration of supply chains will impact traditional private international law considerations. And now turning to decentralized autonomous organizations, or DAOs, some experts discussed the issue of DAO qualification and drew a parallel with the concept of trusts. Experts discussed a potential future HCCH DAO convention, which would address the notion of DAOs, the law applicable, and the automatic recognition of DAOs that have been validly incorporated, instituted, or organized as a new form of legal entity. One expert discussed whether the applicable law of a Maverick DAO could be its code, or whether the applicable law could instead be based on rules of law that are generally accepted in an international, supranational, or regional level. Another expert also noted that there is no comprehensive guidance on how decentralized autonomous organizations should comply with securities laws, and suggested that this is an area that requires further work. This work might require a jurisdiction-by-jurisdiction inquiry, given the lack of comprehensive guidance. A separate expert also discussed the issues relating to non-fungible tokens, or NFTs, as a potential topic of future work for the HCCH. This expert noted that the characterization of NFTs, whether as property or not, should be studied in relation to potential private international law issues. There was broadly recognized consensus that depending on citers is not the best choice for complex digital assets. One expert noted that questions needed to be answered in relation to discerning the law of characteristic performance. Other experts pointed out that the anonymity, as well as the immaterial nature of digital assets, would make private international law issues important to address in the digital economy. Some experts pointed out that civil actions and torts in relation to the digital economy and the situation of private international law issues in relation to Islamic banking and other finance or banking transactions in Sharia tradition influenced jurisdictions may also be possible fields for further study. The sister organizations of the HCCH, the United Nations Commission on International Trade Law, UNCITRAL, and the International Institute for the Unification of Private Law, UNIDRAW, also featured on CODIFI's program. UNCITRAL emphasized the importance of coordination between their organization and the HCCH, in particular on the private international law aspects identified in 5 key topics: artificial intelligence and automation, data transactions, digital assets, online platforms, and distributed ledger systems and technology. UNIDRAW noted the need to update and adjust the existing legal instruments in light of new applications brought about by novel technology. UNIDRAW also spoke to the draft principles being worked on at their working group on digital assets and private law, focusing on the principle relating to private international law. UNIDRAW noted that the input of the HCCH would continue to be welcome in the development of these principles, and that both organizations would continue to work together in moving these principles forward. The 3 sister organizations reiterated the importance of cooperation and coordination between the 3, as well as the fundamental role of their respective members in directing the efforts of these 3 organizations. And so in conclusion, this was an overview of the various threads that emerged from the HCCH CODIFI conference, from private international law issues and trusts to securities and choice of law through to DLT, crypto and digital assets, CBDCs, and the metaverses. We were privileged to have had the insights and expertise of our 93 speakers with us this week. Now, these insights will be reported to the members of the HCCH in preparation for the next meeting of the HCCH Council on General Affairs and Policy to take place in March 2023. They will inform HCCH members as they decide on the work plan of the organization. The HCCH is grateful for the support we have had for the CODIFI conference. We hope that you have enjoyed this week at CODIFI as much as we have putting it together for you. We have loved having you with us. Thank you, and from my team at the Permanent Bureau of the HCCH, a very good morning, good afternoon, good evening, and good night.